For most people, it all started in 2018.
We begin with breaking news this hour about Cambridge Analytica.
Our top story, political consultancy firm Cambridge Analytica at the center of the Facebook data sharing scandal.
Cambridge Analytica.
Cambridge Analytica.
Cambridge Analytica.
Cambridge Analytica.
Cambridge Analytica. That's a classy name. Cambridge Analytica. Not to be confused with their competitor, Oxford Think-em-ups.
While it may have been easy to joke about, when it was discovered that Facebook had been harvesting personal data and providing that data to third parties such as Cambridge Analytica, it caused major controversy and raised serious questions about data privacy and data protection. So what does all of that have to do with football? Well, earlier this month, ex-football manager Russell Slade, 400 players, and a global sports data company decided this issue was important to them too. Now, they are all prepared to sue gaming and betting companies over the use of player data. Today, we explain Project Redcard and what it means for the future of data in football.
Yeah, Project Redcard is essentially a claim by over 400 players at the moment.
Richard Dutton is the director of Elias Partnership, which is a data advisory company consulting Project Redcard on their case.
Professional footballers from all the leagues in England, from Premiership down to League Two, claiming against the unlawful use of their performance and tracking data, which is classified as personal data.
So how did you get involved in this project?
Well, about 9 months ago, I was approached by Russell Slade and Jason Dunlop, who are the co-founders of Global Sports Data Technology Group. And they came to see me and my business partner, who my chairman is Dean Armstrong QC, one of the leading data and cyber lawyers in the UK. And they came to us with an idea, concept saying, we think there's a problem here with the data being used in football. And that's how we started.
What help are you providing to the project?
So what we provided was essentially an opinion from leading counsel. So Dean, as Queen's Counsel, will put together a significant document, which was used by us then to go and talk to the law firm Freese, who are leading this in terms of bringing the proceedings against target defendants. And they concurred with leading counsel that we had something that was really interesting here, and they were prepared to support it.
And so what's kind of the main objective of the lawsuit? What's the end goal?
Well, Russell Slade has been in the football game, for a long time, 40 years. And he's managed a number of clubs and possibly over 1,000 players in that. And he's very determined that what he calls the bread and butter footballer is going to get compensation for their personal data, which has been used, because it's a short career. And he feels very strongly about that money that's gone out of the game coming back to the players who deserve it.
Can you provide us with a little bit more context? Who currently owns the data that you guys are trying to get for players?
Right. So that's a really good question, because it raises the issue of ownership of data. And it's really important, I think, to clarify at this stage that we as individuals, we can't own data, but what we do have are data rights. We have rights about the data that is personal to us. And so the context here is looking to protect those data rights so that when you look at the regulations at the moment, and this has been the case for many years, not just since the GDPR, that you have to have a lawful basis for using somebody else's or processing or controlling somebody else's data. Personal data. And that's at the heart of the matter of this particular project.
So as it stands right now, who owns the data that you're talking about in regards to football and the players?
So the ownership issue is translated into actually, have you, Mr. Organization, who is using my data as a player, got my permission? Have you got my consent? Have you got any other lawful basis for using it? processing it and profiting from it? And we believe the answer is no, you don't.
So players aren't asked, for permission or consent, or there's no contract they sign when they sign their contract about data?
They do sign contracts, and as you would expect, image rights are clearly mentioned in those contracts. But personal data rights are different from image rights. So let me give you an example. You and I both have personal rights. Well, I certainly don't have any image rights because nobody's going to pay me for my image to promote their product. So the principle around image rights is actually using somebody's image to promote something. Personal data is different from that. And that's what the claim contends. That's what the players believe, is that they've never been asked for their permission. They don't know where this data is being used, and they're certainly not being compensated for it.
Just what type of data are we talking about here? Are we talking medical and tracking data or goals and assists?
We're talking about performance and tracking data. So that is the data that is the number of passes, the speed, shooting accuracy, all of those things that make up the profile of a player, which then is being aggregated by many of these companies, and it's being sold and then processed again and profited by another company. So that's the process that is happening. And it demonstrates that, certainly from the player's perspective, there is effectively, they've lost control of their personal information.
At the moment, I think a lot of fans assume that players' tracking and their data just stays with the club. But it sounds like you're suggesting that it goes to third parties after the club gets that data.
That's exactly right. So the clubs aren't part of this claim. It is exactly what you've just described, is those organizations where the data has gone thereafter and where it ends up. Because one of the principles around certainly the GDPR is transparency. And there isn't transparency about where it's going and who's using it and who's profiting from it. But certainly a lot of companies are.
Kind of just to sum it up a little bit, a betting company or a gaming company like FIFA or Betfair or, one of these companies could have all of the data that a team has, and a player never agreed to give it to one of those companies.
It's essentially companies like that, or companies in the gaming and betting industry, are doing exactly that, aggregating data, personal information, and they don't have the player's consent.
So how much money are we talking about for each player here? Millions? Thousands? Can you put this into context for us financially?
I think we have to provide some context for this. And the context for this is there are lots of potential defendants. As you've correctly identified in those sectors of gaming and betting and other sports data. But the actual money that players will be entitled to will depend on their career and which level they've been playing at and for how long. But we are looking at being able to take this claim back 6 years under the statute of limitations. So, it is fair to say that the total quantum of the claim, we believe, will be in the hundreds of millions. And what that brings to each individual player will depend on their particular playing career.
Okay, so there's a lot of money at stake here in this claim.
We believe there is, yes, we do.
Obviously, you are going to be fighting for this against someone. What might the opposition say, against your lawsuit?
Good question. I think there'll be lots of potential arguments. That it exists in the public domain, being one of them, being it's just fact and it's available information. So the example I try and give to explain and how we would counter that is there is absolutely nothing wrong with you and I as fans of football taking notes if we're watching a game, whether it's on TV or actually at the game itself, because we like statistics. We like seeing how players are performing and saying, well, I think, That's my guy. I really like this guy. I'm going to see how he performs today. There's nothing to stop us doing that. And in fact, it's perfectly lawful. What isn't okay would be then for you and I to then sell that information on to a third party using that player's information, personal information, for personal profit. That's the issue here.
I mention that because some people online have said that, and I'm going to quote because I'm not a, legal expert, but quote, an important principle of intellectual property law is that you cannot copyright a fact. And this is something that came up with Major League Baseball's Player Association and CDM Fantasy Sports in 2006. And in that case, the federal judge, this is in America, so we should make a big distinction there, ruled that stats were facts and therefore in the public domain. So why would it be, I guess, different in this situation?
Well, I think there's a couple of answers to that being different. You're right to point out it's obviously American jurisdiction, but there's been a similar case here in that respect around what were the scores. And so the newspaper is being able to publish the scores of the matches every day or every week is fine. But we're not talking about intellectual property law here. And we're not talking about copyright law. We're talking about data protection regulation, which very specifically provides rights to a data subject, and in this case, professional footballer. And that's where the issue lies. So I think those people who may be using that as an analogy are looking at the wrong regulations and the wrong law.
What are some potential side effects or ramifications of this lawsuit if you end up winning it?
I think the most significant impact will be the recognition that personal data is going to become one of the most valuable asset classes in the world over the next 3 or 4 years. Because if we look back to how things have matured, if you like, in terms of people's understanding of data, one case that everybody will be familiar with is the Facebook v. Cambridge Analytica. And what that did, apart from open everybody's eyes to potential challenges to democracy and things like that, what it did was to establish the commercial value of data. So that is where I see a significant impact.
So now people's data has an economic value to companies and to themselves. And so it's about kind of protecting that and ensuring that they keep it.
That's absolutely right, because this is not that different from some of the challenges that are being laid down to big tech about the way in which they're processing data and using personal data, not just within their own walled gardens, but where that is going thereafter. And a number of the data regulators, the data protection authorities in Europe have taken a very tough stance on big tech on that front. And I don't see that relenting at all.
What are the next steps for the project? What's coming up in the upcoming weeks or months or, in the next year?
Well, the immediate short term, we hope to be sitting down with some of the target defendants to discuss the player's claim. And that's the most immediate thing. We're hoping that we'll be able to have some constructive conversations. But like in most things, if we aren't able to do that, then that will be the time to take this to the courts to support it.
Are you a fan of football today? Then why not support the show and sign up to our new Patreon page? You'll get access to bonus episodes, full interviews, and extra content. Just go on Patreon and search Football Today. Now, back to the episode. While the fight for player data rights is just beginning here in England and the United States, the battle has been going on for years. To get an idea where Project Redcard might be headed, we spoke with Mike Clohisy of Beasy Blockchain Made Easy. Clohisy studies data protection and has been a sports lawyer in the United States for more than 25 years.
Privacy concerns are on the rise. We know that. People value their privacy and many believe it's a fundamental human right. Further, data breaches have become ubiquitous. So As a consequence, politicians, regulators, advocates, and academics have paid much more attention to increasing privacy rights in the last 5 to 7 years. And the European Union has led this effort with GDPR, which harmonizes data privacy laws.
Say hello to GDPR. It's being described as the biggest shake-up of data protection laws in a generation, giving ordinary people unprecedented control over the information companies hold on us. So what is GDPR?
So in the US, we have a patchwork of states that regulate data privacy. With respect to how data is protected in the sports leagues, the players' unions play a large role in that. Part of that mission for the players' unions is to protect the players' rights and the players' privacy. And I think they do a very good job in doing so.
Can you go through a couple of the big leagues in America? I'm thinking of the NBA, the basketball league, NFL, and Major League Baseball. How have they approached this issue?
So each league and each respective players union in the U.S., it's sort of a balance and a counterbalance. So with respect to collective bargaining agreements, they wield enormous power. And so as they get involved with union and management and they sign these collective bargaining agreements, the NBA in particular does a very good job. Their collective bargaining agreement has a wearable provision that it says that there's no wearables in games. There's players have full access to data that's collected. The staff has limited access to the data. There's player data in contract negotiations. And I think that's a contentious issue where or people fear that you're going to take the data if somebody's losing a step on the field. Is that going to be held against them in a contract negotiation? And if so, there's been provisions within the collective bargaining agreement. I think the NBA has sort of led the effort, and they're very progressive in that. There's a $250,000 fine if they do that and are caught. There is a presumption that the players own their data about themselves. And I was reading part of the provision within the NBA collective bargaining agreement last night, in fact, and it said parties will continue to discuss in good faith both the sale of athletic biometric data as wearables in games. What does that suggest? I think it's still a work in progress.
What about the NFL and Major League Baseball?
The NFL, by way of contrast, they've signed a new 10-year extension earlier this year in March. Prior to that, there was very little language in there with respect to sensors and biometric data. So they've formed a partnership with Zebra Technologies. They work with third-party vendors, for example, that track acceleration, field positions, distance covered on each play, miles per hour. They use that content, and it's for performance evaluation, but it's also used on the NFL's mobile app, Daily Fantasy Sports, also sports betting, and obviously their broadcast partners. What was interesting is I looked at Section 12 of the new collective bargaining agreement as it relates to gambling, and then I looked more closely a page or two later at Section 14 regarding sensors. And the NFL may use data concerning players' performance and movements collected from sensors during NFL games commercially, included but not limited to broadcast partners. What's the relevance? Well, the data collected and monetized for gambling will augment the league's all revenue provision of the CBA, with a percentage going to the players. What does that mean? What's the relevance? In my opinion, I think what they're saying is that as part of the all revenue provision of the CBA, the NFL collects additional revenues and then it's distributed to the players on a pro rata basis. However, although they're conceding the fact that the players own their own data, they can't use it for any commercial purpose. That's a concession that they made.
So they've taken advantage of their data commercially and, made some money that way, but the players can't do it themselves. It has to be done through the NFL. And the NBA, they have also kind of conceded that their players own their own data.
That's right. I mean, with respect to the other large sports properties in the U.S., Major League Baseball, they have an agreement with the players about wearable technology. Their labor agreement expires in 2021. It's obviously interesting to watch what they're going to do. And I think the use of tech and sensors, as I recognize or from what I've read in the past, it's voluntary, so the players may opt out. But the players do have access to the data, and players are to be made aware of who in the organization also has access to the data. So albeit that's a little ambiguous. It's their right, and that's what's certainly within their collective bargaining agreement as it stands now. I do know that they have a joint committee on wearable tech between Major League Baseball and the Major League Baseball Players Association. I do think that they're probably going to take a look at this a little bit more closely and maybe take it one step further than the NBA, which I think has probably been the most progressive as it relates to player data. As you recognize, probably throughout much as you read some of these agreements, you realize that there's obviously relationships that exist between the broadcast partners and also the gambling and sports betting operators. I think the issue comes back to really the essential fundamental questions. Well, who owns the data? How is it controlled? How is it regulated? And again, how can it be monetized? Who's selling it? And who's getting a piece of that entire pie?
So I just want to go back to basketball for a moment. You mentioned that the penalty was $250,000 for using this biometric data in contract negotiations. So are you saying that the teams can't use that at all when they are talking about negotiating over a new deal? I mean, because that's pretty important because players might want to use that to show how talented they are.
Sure. I mean, it's a double-edged sword. I think where they're going, and I think with respect to the collective bargaining agreement and the union reps, I think their position is that athletes have injuries. So, can the argument be made? There's a myriad of issues here. If a player gets hurt, and is that injury going to be held against them or her for their injuries? And is the team going to use that injury against them or perhaps even their age? So you start really kind of peeling away that onion. You start to realize that a player, for example, has at 22 has run a particular speed on one of the metrics tested, say, in the NFL or even in many of the other sports where they test velocity and speed and timing of that speed. Well, if they lost that, the intangibles may change as a player develops. So I think it's really important to focus on that and not to be used against that particular player if it's being tracked and they realize it in the second half of say, a football match between Manchester United and Arsenal. You realize that this particular player tracked over a particular set of games, and in that particular game, they realize that that player has lost a step, really. Well, is that going to be brought up? I mean, everything's being filmed now. Everything is obviously on tape. They're quantifying the data, they're disseminating the data, and it gets pretty granular. So, are you going to use that against a player in a contract negotiation? The NBA, or conversely, the NBA Players Association, has counter-argued and made it a point to argue that point and say that they don't want that player data use to be used in those contract negotiations because they feel that it's probably more of a detriment to do so.
We've spoken about America a little bit, but obviously it's a little bit different here in Europe where we have GDPR. Can you explain the new rights that GDPR has provided, people, but, in this context, players? I understand there's like three main rights that people get as data subjects.
Like any other company in any industry, sport clubs must also apply with GDPR. So when the applicability criteria of this law are met, GDPR applies to the employer-employee relationship and data sharing. So what does that mean? This means that the clubs will have to respect all the privacy rights granted to their players, coaches, and members of staff. I know there's three particular provisions that I think are relevant here, which are the right to access, the right to portability, and the right to deletion, which is really also known as the right to be forgotten.
So those are some really interesting rights that players kind of get as a result of this. And I want to focus on a couple of these and explain what it might mean for European football. So obviously, I understand that, we're not in a courtroom right now, and we're playing out some kind of hypotheticals. So we'll have that caveat. Let's say Ronaldo moves to a new club. Could he say to one of his previous clubs, okay, every record you have of me and my goal scoring and my data can be deleted because it's related to me and I don't want you, my previous employer, to have it? Could he, in theory, tell his ex-club that he doesn't want any record of him at that club?
No. Under his player contract with the club, his on-field performance becomes part of the public domain. So when he scores a goal, that content is then owned by the leagues and the clubs in cooperation with the media rights deals that they've agreed to and signed with their content providers, whether it's in the broadcast or the OTT space. I would say sort of the right of portability and the right to access, it's spelled out in GDPR. And I think what's really important to remember is it's a lot of these rights are not absolute rights. So there's limitations on what can be ported.
So what you're saying is that this is not like a black and white issue. There's a lot of gray in this area.
Yeah, as a general principle, the data controller, the data owner is responsible for the personal data of all its players. In the event there's a data breach, we're obviously looking at cybersecurity issues as it involves this as well. Things can get more complex. So, you certainly data preservation, data management, data governance is a big part of this construct. So each situation should be assessed case by case. But in a nutshell, under the GDPR, sport clubs as data controllers are responsible not only for their own compliance, but also that of the processors that are working for the club.
I think you said something interesting, which is that teams or clubs are liable, for any data breach. So kind of what you're saying in a way is that a player, let's say, Liverpool Football Club was hacked and private data about players was stolen. Those players could, in theory, sue the club, for that data breach.
Data breaches are ubiquitous. I've read recently some of the statistics and they're alarming, and it certainly affects sports enterprises as well.
I think something that's also really interesting about this, and I see potential issues, is actually with young players. In the UK, you have clubs with academies, and in the United States, you have kind of college sports. And in both of these situations, the players don't have a union or organization that are kind of looking out for them. And they seem really vulnerable. I mean, would you agree that those are kind of the maybe most vulnerable people in this situation?
I would absolutely agree that young players are vulnerable. And in particular, I think some of the younger players that are coming up in the EU and the developmental leagues. I also think, by way of contrast, and similarly in the US, I think you have college athletes that are not unionized. So really the question remains, who's protecting the players that are in college? Again, there's no union. So I think there should be greater scrutiny and more regulation and more protections in place for some of these players. I mean, regarding the players that join a sports club when they're very young, it's important to mention that personal data provided when they were children can be deleted at any time. So I think parents need to play a larger role. But really, to your point, I think the youth and the vulnerable youth are sort of put in a position. So, for example, if a coach comes up to a young player, 10, 12, 14 years old, and says, put on this wearable vest or an RFID tracker, and the player's not going to know what that is. They're just going to do what the coach tells them to do. I think it's extremely important to protect the vulnerable and the kids, which are involved in a very large commercial enterprise.
I've seen a lot of people online say that this is just the tip of the iceberg. What do you think the future looks like in this area?
I think the Project Red Card in particular, the legal action, is really one to watch. And that has a potential, number one, to raise awareness in the area of athletes' player data rights. I think number two, it moves the needle back in the direction of where the players will have more control over their data and have the ability to monetize it. I'm certain industry stakeholders are watching this case very carefully. There's a lot at stake. I think it's probably also addressing what I think is a lack of case law to really sort of figure out sort of the fundamental questions of really who owns the data, how it can be monetized, how it's regulated. Some of those fundamental questions that I indicated earlier. I also think, too, and more importantly, who can benefit from it and monetarily. I mean, there's relationships between the sports teams, leagues, third-party broadcasters, gambling operators. So there's a lot of money going back and forth, and it's really essentially the players' data. So I'm not saying that the leagues shouldn't make money on it. I think the players, on a sort of basis of almost unjust enrichment under contract law, perhaps, just as an equity standpoint, I think they should be getting paid as well. How that mechanism is going to take place, I'm not sure, but I do think Project Red Card will maybe flesh out some of these unresolved issues.
Richard Dutton is the director of the data advisory company Elias Partnership, which is consulting Project Red Card. Mike Clohisy is the president of Beasy Blockchain Made Easy and has worked as a sports lawyer in the United States for more than 25 years. The music for this episode was provided under the Creative Commons license by Blue Dot Sessions, and you can find more information about those music tracks in our episode description. This episode was co-produced by John McKenzie. I'm Josh Schneider-Weiler, and thanks for listening to Football Today. And before you go, if you're a fan of the show and would like to support us, please sign up to our Patreon page where you'll get access to bonus episodes and extra content. And if you can't spare the cash, tell a friend instead. Thanks for joining us, and we'll see you next time.